Greetings, loved ones. Welcome to another episode of figuring out what the hell we're trying to do here. So, petitions, back to this. Again, thank you everybody for attending and graciously appreciate all the efforts we're putting in here to drive this thing forward. Again, I'm tired of going, and I haven't gone backwards in so many years. I've almost forgotten how to, and I'm not going to start remembering how today. This is all about forward. I don't care what gets in our way. If God be with us, who can be against us, right? Can you imagine a person, a fiction, trying to get in the way of a man or woman doing this stuff, having restored their inherent rights, having restored our property rights? Never mind inherent, that was a little bit even too fancy, although it implies an inheritance of some kind. Which inheritance? Well, the one we were born with, the one that the state really wanted us to not have. Otherwise, they wouldn't have spent this much time trying to cloak the thing. Good thing there's a maxim for that. So I'm going to talk here just briefly about the petitions again. So here's where this is going to start to shape up. I realize today it's Saturday here for me, right? Today's Saturday. See, I don't even know what day it is. Saturday, so tonight, so that leaves tomorrow. So that means I have to have a lot of this basically shaved and prepped and presentable by the end of tomorrow, so that the loved ones here on Monday can now take it and rip with it and then still get it all filed, et cetera, et cetera. So really, tonight's portion, I hadn't made a whole lot of upgrades to the petition other than a couple of sentences, but this is why it's actually going to be more materially important for us to just kind of rip through. Again, I'm going to share from Gibson's books, petitions, which coincidentally, okay, in the affidavit class that I do in the morning, oddly enough, right after affidavits comes petitions. You know, again, laid out in the book that way. So, ta-da, all right, for people with equity eyes, that's pretty much a no-brainer right there. But just before I share this, I was trying to figure out how to highlight this right before we were going to share it with you all, and I wasn't able to do that, so you're going to have to bear with me. So for tonight, just follow with where I'm moving the cursor around. Again, we can take our time a little bit. There's some pretty meaty sections here that we need to talk about quickly. After that, the version that I post here or share through Kim, I will actually, by then, figure out how to highlight this stuff, and I'll just give it to you, the highlighted sections. And as a matter of fact, I'll go back and highlight. Okay, that's too much.
There. We'll see you now. Better.
See. Well, what was I saying? I'm going to go back and highlight all the other stuff that we're working on as well. Again, when we're talking about Gibson's book, you flip through 5 or 6 pages of that stuff, and it's like you almost can't even distinguish what the important stuff is because there's so much of it. I'll highlight in various colors, yellow and pink and et cetera, just to indicate like severity levels, or okay, this one's pink is really, really, really important. Yellow, pay attention to it. And green, whatever. We'll develop some kind of a scheme or a color breakdown here for everybody. But anyway, well, long story short, I'm going to have this petition right dialed in by the end of tomorrow's class. So I'll be kicking some ass on this tomorrow. Our petition's in good shape. Again, it talks a lot. There's a lot of meat in there. It provides a lot of opportunity. It gives us the chance to get this thing rolling the way we're supposed to. And you're going to start to see here as soon as I share my screen, share the screen. Let's see here. Okay, we need assistance. The little Sherry icon-y thing is not even. Where'd it go?
The 3 dots.
All right. Okay, remember, loved ones, the 3 dots. It's all about the 3 dots. Okay, got it. Okay. Petitions generally considered. That's one way of saying it. How about a petition specially considered? Ooh, that's a lot better. General's public, as we know, as we've been discussing here for a number of months. So a petition is a written request, again, addressed to the chancellor or chief judge or whatever judge it is in your case that you're already dealing with. However, if you go start your own petition from scratch now, bringing your own claim, they will actually kind of in the background, certain judges will take a peek at this, or the clerks know, oh, here, look at this claim. It's straight up equity stuff coming at you. Okay, Judge Johnson, he's the guy for that one. Versus these 4 judges who aren't as experienced, right? Like they know. As a matter of fact, I've been led to believe, and I was shown about, basically, you can kind of go shopping for your judge. I'm not quite sure how you pull this off, but somehow you can go check the pedigree of a judge and what he's presided over, what he's been, a judge for, and if there's been any equitable things in this judge's bag of tricks of experience, you might want to go call on that judge to hear your case because he's got experience in equity. And you can say, nope, I don't want that judge. Nope, I don't want this one. I like this one. Literally, you can just like shopping for a car. Again, in Canada, I've never heard of someone pulling this off. I haven't done it myself, but apparently this is available for our consideration. So right in the what are we talking about? The 4th sentence here. Petitions for interlocutory orders. Again, this one is something we want to keep an eye on. For example, Bryce here, he's involved in a certain something where the Crown, the state, is coming after him for a certain something. So right at any point of that case where the state or the Crown is coming after you, you can petition the court for an interlocutory order. If you actually just listen to the way that word sounds, interlocutory. So something's that means it's very involved. It's very involved. It's very involved. It's intertwined. And locutory almost sounds like something that's locked into place. And then something might happen after this thing gets locked. What an interlocutory order does is when you bring special evidence or special consideration to the court, hey, Your Honor, this is important. I just came up with this one this morning. I think you need to hear it. Boom. And based on what it is you want to tell them, you want to do it through an affidavit brought by a petition seeking, in Bryce's case, an interlocutory order so that civilly we can deal with a title problem that may have an interesting effect on a criminal case over here. That criminal case will go poof once you fix your titles civilly. And again, I'm going to suggest, okay, Bryce is in a shotgun situation, so we're kind of stuck with doing it this way. But get ahead of the game here a little bit. This is why I'm suggesting go file your petition under urgent circumstances, that this incredible knowledge and wisdom having fallen into my lap, Your Honor, I've been directed, or I've been instructed, or I've been told to come bring my claim and have the judiciary look at it and make a determination, declare these titles. Now, again, this is where I'm going to suggest we go to court to have our stuff recognized. Don't go to court saying, give me my stuff back. We've actually had a loved one in the past where the judge kind of said to him, well, what is it that you want? Or what is it you're trying to do? And the loved one here says, oh, I want my name back. And the judge literally says, you've already got it. So then my friend was like, oh, crap, yeah, you might be right. Shit, I wasn't expecting that for an answer. So then he kind of got stumped, didn't know what to articulate on the fly real quick, such as, well then, Your Honor, if it's by admission of the court that I'm in possession of a name, I would then like to have that name declared. Because the way I see it, if I'm coming to you, Your Honor, in a dual capacity, can we have some type of court record or a court document, signed, sealed, and delivered, issued by the court stating that me, this guy, has a complete title to this particular freehold estate? What's the freehold estate? Well, that's a type of estate that's attached to our birth certificate that we know very little about. So, Your Honor, let's just establish that this thing's real, and let's just establish that I, the man, by this good, righteous Christian name, am expressing an interest in this thing, and as such, I have priority. Why? How can you prove you have priority? Well, no one else is legally able to express a priority interest in what is fundamentally yours. I can't say, hey, Carol, you know that birth certificate you got there? I'm going to express a priority interest in it. And you're like, well, how the hell are you going to do that when I haven't granted you that? And then I'd be like, well, okay, yeah, shit, you're right. See, it instantly falls apart. Saying, this is what I'm trying to say, nobody else out there, any person, can express a paramount interest. The big enchilada. Only we can. Can you believe it or not? The whole system feeds off of scrap titles. It's like the shit we don't want to eat that we throw onto the floor. That's what the whole system feeds on. The real meat and potatoes is still on the plate. It's cold now, and a lot of dust is sitting on it because we've expressed no interest in eating it or partaking of anything at this particular table. So we need to bring our claim, however you want to style that, properly through a properly constructed affidavit. This is huge, because pretty soon here, we start to talk about material facts. And to invoke the action of the court. Invoke is a big word. So we're saying, hey, Your Honor, I desire to invoke the court of conscience. That's the equity side. There is no conscience on the legal side. Fictions don't think. They don't have a conscience. They can't randomly decide what's good or bad, what's right or wrong, what's evil and what's great. Fictions are not capable of any of these things. So to invoke a court is to provide something to the court that enables it or warrants it to grant the order you're seeking. Well, what's the order we're seeking? Well, that's in the petition. It's an important part. The petition is essentially going to suggest, through its order, we need a confusion of titles settled upon the petitioner filing an affidavit and attaching an exhibit or two to this affidavit. Furnishes the grounds for me to bring a petition to the court in emergency-like kind of circumstances so that the court may deal with this matter or dispose of it. What are some of these quick petitions? Okay, you can literally file a petition for an accounting. You can file a petition for an injunction. You can file a petition for a declaration of title. That's going to establish the priority. We can file a petition for a number of things. The trick here, loved ones, is which one do we do first? Now, I'm going to suggest the first thing we got to do is establish our priority, or what Gibson's book here talks about. Again, I'm just going to whip through where I've got it highlighted. He starts talking about here pretty quick where we're establishing something called paramount title. This is a big deal. And the evidence of my claim to or having possession of a paramount title is attached in the following affidavit in support of this position for a declaration of priority, right, and interest in a particular chattel or personal property that I am submitting to the court. I'm furnishing the court. I'm providing this to the court. I'm assigning this to the court. I'm depositing this in the court. I'm paying it into there's a number of things we can do here. But again, that's part of our story. We can go over that a few times in a little bit greater detail here. But so the whole petition idea here, there are some very critical components that we have to consider. Giving a cost bond right here, if you can see this, the cursor whipping back and forth, a cost bond is essentially what we turn our birth certificate into. It now can cover all costs, all debts, all fees, anything commercially we need dealt with. That's this thing's duty now that it's made way more valuable. And again, we've put it into the possession of the party that should have had the thing in the first place. So this petition is made by a party to the suit. So we really want to make sure that that's actually important. As a matter of fact, British Columbia legislation, court rules, where we typically are privately dwelling, their court rules suggest you need to identify yourself as a party to the record or as a party of record. So at some point in the very first parts of our affidavit, we're going to want to stick that in there. And we're also going to want to make sure we talk about it here in our petition. because establishing that position, again, super important. I haven't done it yet. It's coming. It'll be in there by tomorrow. So this is going to talk a little bit again about why the petition is important. The petition where a party desires to discharge or reduce a levy or bond. When you want to discharge a bond, that means, if you know anything about slavery, we all got this bond, this yoke, this thing choking us, all of us as public citizens. We have this bond. It's right there. We can barely breathe. But for some reason, we accepted the fact that we can barely breathe, and I'm already starting to turn red, so I'm going to let go. That bond, according to this, can be discharged. Someone has charged you, as in stuck this electrical collar on you. It's charged. It's attached to you. Who did that, by the way? You did. Can you imagine you charge yourself with having to live this ridiculous life of a bond servant because of our poor choices? How ridiculous is that? And again, that's why the whole system was set up. Well, if you're going to volunteer to do that, boy, have we ever got a system for you? Sign right here. Come this way. Follow us. Okay, so we're talking about discharging that thing. So now that it's discharged, you can literally take it off. You can go, oh, wow, I can finally breathe for once. I still have this thing in my hand, though. What do I want to do with it? Well, take that bond and now stick it around the trustee's neck and turn it on. Charge it. You charge it. We charged the wrong party when we volunteered to serve Caesar. We had an option. This is what we're trying to get to the bottom of here. So having that bond discharged is a pretty good place to start. In proceedings seeking extraordinary processes. Anytime we are seeking an extraordinary process, I got to do it through a petition. Why? Here's why. Because on the public side, they don't really have too many extraordinary processes waiting for you in the background. Because publicly, all you can actually do is show up as a public citizen and apply something that's already there. Okay, so you got some public laws, some public shit going on over here. You go take a scoop of that and you say, I wish to apply it to this situation. Okay, well, what if there aren't a whole lot of equitable reliefs there? What if there's not a lot of extraordinary remedies hiding in their ointment? Why would you want to apply that if it's actually not going to be the sunscreen that you actually need? You're wasting your time. Seeking extraordinary processes or extraordinary reliefs must be brought by petition. What are they? Real quick. An injunction is one, specific performance is one, an accounting is one, an appointment of personal representatives. Those and receiver manager. Those are the five. That's all we really got to worry about. The accounting, yeah, that's pretty important, but that comes after. That comes after the new trustees have been appointed. They can't grant an accounting until they've granted someone power to do it. Make sense? Apple in the cart kind of thing. So this is going to say, okay, we're bringing an extraordinary process where a party seeks to have something opened or reopened. Okay, it's nice to have that ability. Where a party has been aggrieved by some other interlocutory order, the court has yet the power to modify it or vacate. That means, eject, get rid of the whole thing altogether. Here's a nice one. Where a party is imprisoned for contempt, seeks to be released on a habeas corpus. Anybody who's been around this block with us for a number of years has heard this term, habeas corpus. What does that mean? That means you're out of your jurisdiction and somebody over there threw you in jail. Even though you're not really subject to the laws of that particular place, sort of, kind of, they still threw you in jail. Well, habeas corpus technically means release the body. Corpus, anytime you see corpus, that's corpses and corporations and things of that character. So, interestingly enough, President Trump, in his presidency, not that long ago, right near the end of it, okay, they were setting the door. They were getting ready for all this pedophilia stuff to go down. They suspended habeas corpus to anybody who's about to be tried for all these heinous crimes that the public is about to be made aware of here pretty soon. How or who even has the power to suspend habeas corpus? Now, again, loved ones, remember, habeas corpus, that's an equitable remedy. You're never going to get that on the legal side, not a chance. Although many of us have been seeking this for a number of years because a lot of us know people who have been in jail or are in jail or are about to go to jail. So we're like, for years, we've been scrambling, trying to figure out how do we get this habeas corpus to actually execute and work? Well, here's how. File a petition for habeas corpus as relates to this person. And here's a bond to furnish the release of that man or woman currently being held because they haven't perfected any security interests in their particular stuff. So I'm going to do it for them. Literally. Once we have this power, we can literally do that. You attach your bond to pay for anything that this individual loved one has done. Why would they take that away from the people about to be going down for all this pedophilia stuff? Interesting, because I'm guessing at the end of the day, those crimes are so heinous, they've actually been denied their equitable relief to anything. So I'm guessing the military / the White House / some authority has literally stripped all of these men and women of the ability to exercise their right to habeas corpus. Why? Because they're suggesting you don't even have that right. The shit you people have done is so off the chart. There's no escape for you. So, interestingly enough, right at the bottom here, where a party seeks a restraining order or an injunction or a receiver on grounds arising during the litigation. Okay, so, Your Honor, in the middle of your case, however long that's been, I just realized something. Something just arose. Something arises. When you do this birth certificate stuff that we keep talking about, and you furnish valuable consideration, and you do the deed, and everything, all the circus that I keep talking about, that is something arising. It's actually valuable. It wasn't like that 3 days ago or a month ago or a year ago or whatever, right? So as soon as something arises, the courts can see it. Bryce has already got himself in a nifty situation by producing or providing or getting that thing filed into court. Now we got to wrap it up in his petition, though, which is what we're doing here to get this thing all to execute properly. Oh, here, I already see some meat coming up here. Okay, so we're talking about complainants and is nevertheless before the court in some capacity, ordinarily, either A, as a creditor who has been allowed to file the claim, or number 2, check this one out, as a purchaser of property sold, and so reported by the master. That's something we're very interested in. And this one's even better. As a surety on a note or bond filed in the cause. If I had the ability to highlight that right now, I would. I would make that nice and pink. Why? Because we are deemed to be the surety right now, loved ones. We volunteered to be the surety. That is a fact. So let's roll with this one. This one's huge. Your Honor, as the surety and deemed so there to be, unless there's someone in the court that can dispute that. Nope. Sit down. Of course, that ain't going to happen. Surety on, well, okay, you can call it a note. The birth certificate, yeah, under the Bills of Exchange Act, does it qualify to be a note? Yeah, it does. But let's just call it a bond. A bond filed in the cause. So as a surety for a bond filed and duly deposited into the court in this particular cause, for what? Oh, to appoint a receiver. or a sequesterer, or some other person acting under the immediate and special order of the court. Special order. There you go. So we're talking about extraordinary remedies. We're talking about special orders. Again, see the difference here, loved ones? Special versus general. Two different worlds. We actually never really thought it could have been that cut and dry until we really started doing the equity digging in the last 4 or 5-ish years. We've really come to appreciate and understand, wow, just how much of a distinctive difference there is between these two worlds. Why? Because one deals with the dead and one deals with the living. And here, I'm going to talk about that one right here. Check this one out. Section 794. Section 794. There it is. And right about here, look at this. The most usual cases are, number one, where a creditor of an estate being administered in chancery desires to file and prove his or her claim. And it matters not whether such estate be that of a dead or a living person. Ah, okay. See, you see the significance of that one? Magic. Again, don't call yourself a person here, though. Refer to yourself as I'm the living individual with a bona fide claim in personal property that I am in possession of. And because I am the grantee of this particular personal property, this chattel's real, I have the authority to do something with this. I'm already vested with that right as the surety to it. That's how we stitch your authority in. You come as the surety. The surety actually does have some pretty powerful rights, even if it's only one. And this is really what it is. The surety, upon contribution to a particular debt, has the ability to assign certain rights to the new trustees. You purchased the right to be able to do that. You didn't purchase nothing if you didn't stick a silver coin on it. Once you can prove you're the purchaser, you can instantly prove you have priority. That is 98% of the job being finished to proving you now have paramount title. Look, Your Honor, I got it. I did this and this and that and that. What do you think? And the judge is going to say, well, I tend to agree with everything you've shown me. Stamp. Once you have a court order, this is the indefeasible title I keep talking about. Once you have a court order suggesting you have paramount title or priority interest right attached to this particular property, you are off to the races. Once you can prove it, and once it's a substantial fact, once a court agrees with you, now you can have an injunction granted. Now you can have an accounting done. Now you can have a personal representative appointed, and so on. And the list just goes from there. Be prepared for the judge to say, okay, anything else? Anything else? Oh yeah, there's this, that, and the other. Okay, yeah, got it. Noted. Duly noted. Anything else? Again, have that on standby. We don't really got to worry about that right now tonight. I know we got a few more days of hashing this out to do. But at the end of the day, every time I've heard of someone getting into chancery chambers, equity side, that was always how their conversations finished, was with the judge asking them if there's anything else. They're there to wrap this all up to avoid a multiplicity of suits. So again, we want to bring a fairly, substantial item or list of things that we want to be dealing with here. Okay, so we got the dead thing kind of working out here. Now, right under this, right here, this next kind of, okay, so after the living person, all that is requisite is that, okay, so all that's required is that the court is undertaking. So, hey, court, hey, Your Honor, for the purposes of an undertaking, very cryptic, very cemetery kind of words, right? It's almost like they know we're dealing with dead things. For an undertaking. If anybody of us have watched wrestling, we all knew who the Undertaker was. Scary guy, all black, weird hat, dealt with coffins a whole bunch. They're literally, as Undertakers, are doing just that. I'm not shitting you. This is really how this works. But look at how this finishes, though. Requisite. So the only thing required is that the court is undertaking to distribute the assets among those lawfully entitled to share in the distribution. That is a dynamite statement of interest. So reverse engineer that. Your Honor, for the purposes of an undertaking, I can prove I'm lawfully entitled to share in the distribution of any assets that the court is in possession of and subject to such distribution. There. Prove you're entitled. Ask, require the distribution of the assets. This is why the adverse claim kind of took root. An adverse claim is a special claim against a specific financial asset. Well, we're dealing with assets right here. We're asking for the court to distribute. That means chop it up. Give me what I'm entitled to. Let the trustee take a bunch. Let a bunch go to this. Let a bunch go with it. There's so much there, loved ones. Literally, the numbers are that astronomical to the point where I don't even talk about them because people think I'm crazy for even throwing those numbers out there, which is why I don't a lot. I do once in a while, but let's just pretend it's a lot. It's literally whatever you want it to be. Again, if you want to go up into the hills and do nothing, you probably don't need access to $1 trillion worth of credit if that's what your intent is. Okay. We/us/these types of loved ones, especially the ones in our divergence think tank, coming up with, okay, how do we clean the oceans? How do we fix poverty? Because imagine, what if 1 week from now, one of us nails this thing, boom, unlocks it, has access to Treasury directly. And if that individual is in a position to share, which I'm hoping they are, what plan do you have in place to go and instantly start helping people? Because I hope that would not be very far from on the top few things to do on your list. Again, the Lord loves a cheerful giver. So if that's not you, you're being frowned upon. But something tells me in my heart you are of a charitable nature. That's why we're all here. Again, so what if I have a Lamborghini in the garage one day? I've given 12 of them away to other people. Whatever. Be more giving than you taketh in is all we're trying to say. Now, that's entirely up to each and every one of us. I'm not here to gauge that or control that in anybody. No, that's for all of us to understand and appreciate and go with on our own. I'm going to skip down a little bit more here. Look at this one. So again, dealing with petitions. Well, when an administrator or a creditor files a bill to sell any land of a decedent to pay debts. Did you know our birth certificate meets the requirements of what a decedent is? And by us expressing an interest in that, sell any portion of that certificate to pay debts. That's what we're doing. Moving on just a little bit down here. But if a party, or if he himself makes himself a party by petition, if he seeks to assert that interest, thus, look at this one, where a person, put individual there, where an individual has an interest in a trust fund or trust property of any kind in the custody of the court, or sought to be administrated or distributed by the court. Boom, if I could highlight that one, I would. Another bullet, silver, all the way through. Huge. That's exactly what we're doing, almost in chronological order. How do we assert this right to trust funds or trust property? Well, that's why our affidavit has to be bang on, talking about the trust property. Our petition has to be talking about the trust property. The court must be sitting in possession of the trust property in order to distribute it. turning pages. Oh, here we go. Where is it? Whose title? Where does it say whose title? Oh, next page. Hang on. Yeah, that was it. Oh, just a second. Why am I not seeing it here? Whose? No, it's got to be right here. Just for it's right here. Okay, right here. So when we're talking about being seized of an interest, because you're seized of an interest, you can get rid of it to a receiver. And under orders of the court, they're going to exercise this thing. Look at this though. To whose title is paramount to that of any of the parties to your suit. And the individual claiming the paramount title must file a petition in the court by whose authority the property has been seized, setting forth his title and praying to have the property returned to his possession. If I could highlight that one, I would. Reverse engineer that a little bit. Look what it's saying. We literally take these little statements and we spin them around a little bit, and you put the word I or put you in there. I'm setting forth my title. I'm praying to have the property returned to my possession. Which property? The equitable interest for my enjoyment in a life estate. That's what I want to be possessed of, not a legal interest. Get rid of that thing. So right here, the reasons why a petition is necessary in the above cases are ordinarily the following. The court has no jurisdiction to determine any question in dispute unless it is raised by some proper pleading. Hey, Your Honor, here are my pleadings in equity based on the excellent stuff I've done. And look, I'm not even in possession of the character anymore. So clearly I cannot be acting in person. That fact alone gets the job done. You can literally stop right there. Your Honor, decree that so. Look, I'm not in possession. I can't be liable. I have paramount title. Decree that, please, and put your stamp on it. Thanks. That alone. Again, that's way too light duty for me. That's way too crayon for me. I wouldn't do that. I got to make it prettier for some reason. But for the layman out there or the man or woman who just stumbled across this stuff three days ago, that type of wording might be very suitable for that individual because they don't know a whole lot else. So now when the judge asks you, did you write that sentence? You can literally say, yes, I did. If you show up with 6 pages of Darren's language and the judge asks you, hey, did you write this? Yeah, you're either going to volunteer for a punishment or tell the truth and just say, no, Your Honor, I didn't, but I have a pretty good grasp on the principles and the doctrines it's talking about. For example, I know that such and such, and I believe that such and such. And boom, you just got yourself out of it. Versus saying, yeah, I wrote this, and then hoping he doesn't ask you a question. Really? If I was the judge and I see you kind of acting all fidgety and weird and you're hoping I don't ask you a question, I'm going to ask you 3 to test you. That's the judge's job, is to test you to see if you're capable of managing your own affairs. $7.95. Okay, so we're going to talk about the frame and form of the petition, which we're already dealing with. Again, at the end of tonight's program, again, I've got 20 minutes. For the 2 or 3 sentences I've added, I'm not even going to talk about it tonight. I'm just going to post it again like we did the affidavit this morning or with the petition yesterday when I added that orange paragraph. These 2 little blue, I think these ones are in blue. There's 1 sentence, three of them, I think, is all I added today. But again, you're going to see the significance of it. By tomorrow, we're going to have a much better working version of all this stuff. I'm going to smash on both of them, the affidavit and the petition, by tomorrow, because these things got to be done. I've pretty much already got the deed punched out, so that's pretty solid. It's pretty set in stone. That's there, ready to go. All we really got to do is post it, and then you can just kind of plunk in your information as needed. But again, all we really need to do is tell the court, hey, a deed exists. You don't have to supply it. You don't have to furnish it just yet. Not yet. The judge, the master, is going to request it. He's going to want to see it. Yeah, absolutely. But that buys us a little bit of time, because the deed could literally be expressed by voice. So, hey, Your Honor, I know there's a deed exists out there. He's going to say, oh, yeah, show me. Well, sit down, grab a pen and paper. I'll dictate it to you. You ready? Go. Do any of us have the ability to express a deed of trust on the fly like that? Hammer off the 4 key components of a deed of trust, support it with a few other facts. You know what? Maybe in 3 days, one of us could be, especially once you see it and you highlight, okay, this section, this is the meat. If I had to say anything off of this one particular page, this is the dynamite sentence or mini paragraph right here. This is what I would focus on. This would be what I had to say if I had to say something to a judge. I'm going to have all of that dealt with by tomorrow's events. So right here where he's talking about the only courses open to such claimant are to present a petition, whatever this Latin stuff means, in the cause wherein the receiver or other officer is acting, setting forth in such a petition his rights to the property. So what this is kind of saying here is that they, the trustee, will also present a petition to get this thing rolling so that the trustees can get directions. Hey, Your Honor, we've never dealt with a trust like this before. We don't know what the hell to do, and we don't want to make a mistake. So we're now filing our petition for instructions and how to deal with rights attached to that property and under what circumstances he was deprived of such property. This is where we can spin that, because that's something we want to use right there. Your Honor, here's my cause of action. I've been deprived of property. I wish to be restored of said property. Now, again, I'm of the position, let's just explain that a little bit more than some of our other loved ones in the past that have rolled into courts and just demanded restoration of property. I'm saying let's put some color into that. Let's add a little bit of meat. Because when you roll in and just request or demand restoration of property, that is such a vague term. There are so many different kinds of property. There are so many different kinds of stuff. How would a court of competent jurisdiction grant you the relief you're asking for with such a vague description of it? Not going to get the job done. At the end of the day, the children may have been returned to the proper family. Okay, yeah, that's all great. But did we actually deal with the problem at hand? I don't know. So let's just fine-tune our game here, dial this up a little bit, and suggest, because we are praying for a writ of restitution. Restitution is something technically being restored to you. And if your title is prior and superior to that of any other litigants or defendants or anybody else in this cause or matter, if you can prove you have priority title, if you can prove you have a paramount interest, you win. It's literally that simple. This is why they don't ask for our identification when we walk into courtrooms. In the odd chance that you actually had the person on you, that you can say, what the hell, wait a minute, Your Honor, I just had a stroke of genius. I just had some incredible drop of wisdom hit me all of a sudden. I don't know where it came from, but Spirit just told me to take this thing and duly attach it to the Crown Prosecutor. How do you duly attach it? Well, through a deed of trust, I hereby duly appoint, duly execute, by duly nominating that crown representative, duly electing, duly naming, duly attaching. That alone right there seizes that crown attorney's interest. Boom, you locked him in. He can't get out. You can't get out from this appointment. This appointment is very inclusive. It's very binding. It's got him. So, hey, on the public side, make sure you never bring that certificate into court just in case you ever want to assign it or deliver it to the party that ought to be in possession of it. If you don't bring the thing in, there's no chance of you assigning it. Is there? Yes, there is. You still can. You can still suggest, Your Honor, I am not in physical possession of an instrument that would allow me to redress this particular set of circumstances, this particular legal court. I wish to furnish, I wish to provide, I wish to attach an interest to certificated security registration number 123456789, registered on December 8th, 1972, and issued on March 11th, 2016. There. That's enough information. The court can operate on that. You've legally described some type of property, and it happens to be registered. So sure as hell wouldn't take the judge very long to verify these types of things. He could probably just go right on his computer right there, and figure out whether you're talking smack or not. Oh shit, look at that. The security interest is issued in that name, the same name on a name in my courtroom. See, this is how we can join things in the background. Just have these numbers committed to memory, though, so that if you got arrested right after this show, you can play with your interests. You can express it to a judge. If you don't know the dates and numbers and stuff, you're actually doing yourself a bit of a disservice. We're all fantastic at memorizing phone numbers and our social insurance number, so why wouldn't we memorize this one? Good idea, I'm thinking. Hang on, I got another good little chunk here. Bring forth. Where's the fourth? Okay. Hang on. By leave. So the court will order the petition to be filed and give the complainant or the petitioner, you, of the original bill or the petition leave to answer if it's desired, or if it's required, or if it's expressed. Bryce can actually do that already because he's already filed that thing into the court. The court's already in possession of it. He can motion for leave right now to have a separate hearing to have your titles declared. Your Honor, I'm no longer in the debtor position. I believe on my contribution, I'm entitled to be exonerated of all that liability. What do you think, Your Honor? Yeah. Based on the evidence brought before the court today, the court can make a finding. The court can make a decision upon evidence brought before the court as it appears before me this date. The plaintiff, the petitioner, is entitled to equitable relief, grounded in the facts or in the claimant's efforts where that certificate was lodged in the court. That certificate was paid as securities into court to furnish the provision or to pay for or to allow or to cover the injunction I'm about to decree. Boom. Once you get that decree, now, once you get your titles declared, now motion for the accounting. Because you got the title to prove it. Don't ask for an accounting before you have the bona fide paramount title to ask for it. You got to get the court to agree with what you got first. Once that happens, now, full-blown injunction. Start with the temporary one, Your Honor. Get everything stopped right now. And after a little bit more process issues in the background, the court will reconvene on its own motion in 7 days to grant the temporary into a permanent injunction. That's the one that sticks forever. They can't go from 0 to hero. They need something in the middle there. 0 to temporary, temporary to permanent. You got to, again, we just got to set these points so that they can connect these dots. I have this whole paragraph here highlighted. The petitioner must ordinarily show that his title to the property in question is paramount to that of any other parties to the suit. And if he or she claims under any party to the suit, he must show that he acquired his title before the petition was filed. You got to perfect the thing first. You got to have the title first before you make a filing suggesting you have it. Again, that's kind of in keeping with the doctrines of the grantee position. You got to prove you have the thing before you show up to grant it. You got to have the something before you get rid of it. Coincidentally, we had the thing when we were 16 and we granted it to the state. Well, if that transaction has happened and we can point to evidence of it, again, in your affidavit, Your Honor, when I was 16, I made application for social insurance number, not knowing or unknowingly volunteering to some shit that I really don't want to be a part of. I just didn't know. But you got to state that. I'm on or about. Again, I don't remember if I was exactly 16, to be honest with you. I might have been 15 and a half. I can't really remember, but it's around there. Again, that's incidental. That doesn't matter. Just lay it out there, that on or about. You can be off up to a year or more. The court doesn't really care. Okay, yeah, I was continuing here. Acquired his title before the petition is filed. Look at this. And paid a valuable consideration therefore. That's right there. Okay. Now, when Chancellor Gibson lays this out, take this as gold. This is not up for argument. This is not up for debate. This is not up for, well, I don't think so. Sit down. Listen. And valuable consideration is paid, therefore, to acquire your title. You don't acquire shit without paying for it. You're in the debtor position. How are you going to get something fantastic without paying for it? Seriously? Ain't going to happen. A sin offering. Your Honor, I bring before the court a sin offering. That might get a very interesting response from a judge. Okay, and this thing goes on to say, and his petition must be verified by his affidavit. There's the three key components. You need the affidavit, you need the valuable consideration, and you have to have the title before you come to court. Have all these things dialed. Dean and I have never come close to dialing it like we are doing it now. And yet, we've achieved some pretty incredible stuff over the years. That's why I'm pretty excited about this. I may look calm and cool, but I'm excited about lawnmowers, I'll tell you. Here's just a little breakdown as to how these petitions can be filed. He's actually going to give us a little bit of a breakout. Again, I haven't put this in my petition yet, but I should. Respectfully shows to Your Honor that on the first day of blah, 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 use this. Respectfully shows unto Your Honor. That is a phrase that Dean and I would not have used 10 years ago. Nope. Moving forward. And that he acquired his title thereto in the following manner. There's another dynamite one. Highlight that, please. Your Honor, look at my affidavit right here. Your Honor, I acquired my title thereto in the following manner. On this date, I did this. And then on this date, I did that. And then on this date, I put the two together. And as a result, boom. Lay this shit out, though. The judge needs to see this. And then have any of these evidences attached as an exhibit to your petition. Well, that's pretty slick. And at the end of your petition, The petitioner therefore prays that the said receiver be directed to restore said property to you, and that a writ of restitution issue, if necessary. Wow, did we open a can of worms with that one? That's it. That's literally all we need to do. I know that was a whole bunch of technical mumbo jumbo, but yet at the end of the day, again, watch this video a few more times. Go read some of this stuff. Just let that stuff sink in. We got to show up with like 3 key elements. Got to prove you acquired the title, do it in an affidavit, and add your valuable consideration there. If you get that far, the judge will fill in the blanks. How do I know this? In the Securities Transfer Act, it actually says they're in 2 separate clauses, 2 separate sections. If you start the process and you haven't quite finished it, any appropriate person can fill in the blanks and finish it on your behalf. Okay, fantastic. It even goes on to say this. Even if the assignment was done fraudulently, the court can still act on it if the terms and conditions are still relatively on track. Why would they say that? Why would they say if it was done fraudulently? Maybe, what if you're deemed to be the debtor and everything you do is fraudulent, right? If I got dirty hands, I'm trying to profit from my own wrongdoing. I'm the debtor, I'm the liable party, I'm the fiction, I'm the dead guy. I've got no rights, I'm not an heir to land. I can't do or say shit. I'm literally screwed completely, acting completely in fraud. Well, even if you're acting in fraud, if you do it right, they'll still put it through. Boom, there. It's just how we spin all this stuff. So we need to prove and has been in possession. Where is that one? We're going to suggest that, and we have been in possession of this thing. Oh, where is it? Anyway, you'll see it in the affidavit too. It's in here somewhere. We got to establish that we were in possession of this thing. Well, that's easy. I got it. That's my autograph, Your Honor. On that date, yes, I did. And look, the notary also agreed with all this. Boom. We're off to the races here in a glorious type fashion. When the petition's not proper, you can read all that if you want. It's just going to say, hey, if we make some mistakes or if we do a bunch of no-nos, if we introduce irrelevant, multifarious, incongruous, or otherwise material not proper, they'll bounce it. Again, well, what's that saying? Well, they don't care about your emotional stuff. As a matter of fact, you're not emotional, you're not depressed, you're not a victim. You're so elated, you're so bouncing, you're so ascending right now because you know, based on what the hell Gibson's talking about here, when you put the affidavit done properly, and again, a lot of duality. When you put a lot of duality into your affidavit, spills over into your petition, generates the ability to ask for prayers for relief, wrap all this up in your bond, your perfected security interest, duly everything. Remember, everything's duly. Get this before the court, the chancellor. And again, the chancellor, a master, a senior judge, any of these entities are going to entertain this. That's their job. They know exactly what it is they're looking at. Bryce pulled this off without barely doing any of this stuff. The registrar already told him, hey, once you do this, there's no going back. You're not getting it back. I would have been bouncing up and down. And I hope he was. Look at that. Okay, so I just want to read this one because this caught my eye right here. And while the code allows any and all matters to be brought, that's everything, to be brought forward in a suit between one complainant and one defendant. Nevertheless, where there are more parties than two, the chancellor should not allow matters wholly foreign to the objects of the original pleadings. Okay, so he's going to be doing some stuff here. He's trying to understand or determine whether more parties can be brought into your suit. Because when you set your suit up as one individual plaintiff and one individual defendant, there's not really a lot of room here to be granting others access to this relief. So if this is something that you want to maybe have others partake in your glorious event, then put at all, ET space AL, for defendants and for petitioners. This way you can actually, once your suit is knocked out of the park, you can have your husband, your children, your grandparents, your mailman. You can bring anybody into your suit and attach their interests to yours. That means they can actually have some kind of equitable relief based on your proceedings. I'm not saying that they're going to be taking out of your life estate. No. They're going to show up with a similar life estate in a similar situation, pleading similar reliefs and praying for similar injunctive. You're opening the door, though. But look at how this finishes. Such a practice is not only in violation of the fundamental rules of equity and good pleading, but tends greatly to confuse and delay the final determination of the cause, increases instead of diminishing costs, and multiplies grounds of appeal to the Supreme Court. So all I'm suggesting here is that, look, they would entertain a bill or a petition to have a few people. You're literally setting the stage to have a class action brought. When you have two or more individuals sharing the same stuff, that constitutes a class. You now have the grounds to bring a class proceeding to the judge in chambers, and you can have all types of individuals join your class. But here's the cool thing. Your class closes the moment the relief is granted. Boom. That's it. You can't add now. So bring as many in as you can, because once your matter is dealt with, boom. And I'll show you the legislation where it's actually stating that. So have this all set up a little bit ahead of time. What are the possibilities that you might want your wife involved, that you may want your children involved? And you know what? Let's pretend you're one of the loved ones that has a spouse that thinks you're crazy and thinks you're completely wasting your time doing all this shit. You can secretly, without telling them, make them a party to your suit. You can set up the possibility for them to enjoy something. And if they never choose or never rise or dismiss this or think you're a whack job, then fine. They don't need to exercise any entitlement. They don't need to share in the distribution of the assets. Fine. But at least you gave them an opportunity. That's you actually kind of acting charitably. Again, when I ram my paperwork through here, I'm going to do it secretly naming a whole bunch of people. Who's on the list? I don't know yet. Santa might know. Depends if you've been good or bad. We're getting pretty close to the end of the petitions here, loved ones. As a matter of fact, I think like this thing ends like coming up right here. So this, again, is just a quick overview, just touching on certain subject matters and key issues. So that right here, to avoid the perplexities resulting from the anomalous and reprehensible practice of filing improper petitions in a cause and taking issue afterwards and making decrees on them, our Supreme Court, constrained by the statute, the most commendable disposition to do justice despite such gross irregularities, and having dealt with such petitions as though they were original bills, and having given the consequent relief. That's just a fancy way of saying, you know what, again, as long as we get our stuff remotely fashionable so the court can hear it, we need to be talking about titles. We need to be talking about valuable consideration. We need to be talking about how Party B is now in possession. We need to talk about how the court has custody of the original instruments. That's what warrants the court to act in your favor, to grant the equitable prayers for relief that we've been searching for the better part of my adult life. You ain't going to get it if you don't follow the rules. We can all have the remedy, but you got to play by the rules. I am the biggest non-player by the rules. I was the guy that always wanted to do it the hard way. Not playing by the rules. Again, I just hated being told what to do and how to do it. That's just never sat well with me my whole life. And if my adoptive parents were alive today, they would certainly attest to that one. Never did what I was told. Or if I did, I was always mumbling shit under my breath and displaying my disgruntledness to do it. Especially when all my friends are standing outside the front yard on the sidewalk waiting for me, and my dad says, "You're not going anywhere till you cut the grass." Aha, lawnmowers. Maybe that's why I've got such a thing with lawnmower. I don't know where that came from. I'm gonna have to do a little bit of regressive therapy to figure out where this actually all comes from. Yeah, there's stuff going on there. So anyway, loved ones, okay. We're going to post the revised petition, and you know what? I'm embarrassed to say it's revised because 3 sentences in my world, that's not revising. But again, just be formulating in your head, okay, we say stuff in the affidavit, we need to repeat it right here in the petition. We need to establish exhibits talked about in our affidavit, attached in our position in our petition to create our position by disposition. Kind of weird, I know, right? That's what's going on. So tomorrow's events here is going to be a lot more, it's going to have a lot more meat to it. The affidavit class, I hope you all can attend that one tomorrow because we're going to basically wrap up the affidavit class. And then we're going to wrap up the petition class. Somewhere there in the middle, I might have to have an emergency Zoom meeting to introduce the deed. Or, you know, maybe I'll just tack it on at the end of tomorrow's petition class. Because again, we got to like kick the tires and light the fires. The clock's ticking on us pretty hard here. So again, you're just in a position to absorb, just absorb, just absorb. That's all you're meant to do. And when you're overflowing and there's no more going in, take a break. You got to take breaks for your loved ones. I remember when I first started reading Gibson's, I could only read a paragraph at a time. And my brain hurt. So don't feel bad if you're kind of feeling in that similar situation. I've got a bit of a head start. I've been years deep in all this stuff already. That's why I can just belt it out. But again, we all have the ability to fix our problem, and that's fundamentally all you need to know. And we're getting there. Hang tight. We've almost got it. Anything else? I don't think I really got to touch on anything. Fantastic class this morning. Good classes to come. Thanks for the presentation last night with the Queens and Jody, respecting some smackdowns, respecting some, hey, this is what it is we're trying to do here in the background. This is why we're looking for key people. This is why we're looking for people that can actually manage their own affairs and not bitch and complain the whole time. That can help us get this world in a better spot. And I mean fast. Like fast. Not 6 years from now. No. Literally right freaking now. And Bryce may be in the position where he's going to be one of the first to actually get this shit rolling. And if Bryce disappears, don't let that scare you. And again, I would encourage that guy. If the judge said, "Hey, Bryce, sign this or you ain't getting shit, but you got to be quiet and we're watching you. And if you're not quiet, we're going to take it all away." Again, I would actually encourage Bryce to take the deal. Do it. We're running out of time, man. We need somebody to start cranking out miracles. And it could be any one of you. Just because Bryce has a something going on Tuesday, remember, they don't like Bryce. And they're still kind of giving him grief and friction. One of you who's coming in with sugar and clean hands from the get-go could pull this shit off before Bryce does. One of you could pull this off on Monday. That's why I'm gunning to have a lot of this wrapped up by tomorrow night. Now, I am going to trim a lot of shit. I am going to get a lot of dial this right in as best I can. It's still going to have a technical flavor to it, though, because that seems to be all I'm capable of. Why is that? Because they know who I am. They've been looking at my stuff for years. If I all of a sudden go from red to crayon, they're gonna be like, they're gonna ask me, Darren, did you write this? That's kind of the problem in reverse, because this isn't your style. We know, we've been watching you. Okay, a humbling moment there. But point is, loved ones, this isn't going to be as technical and as hard as we thought it was. We're just going to get this dialed, presented in a nice package, so that any of us can go and accomplish this in the very near future, because the time is at hand. Peace and love to all of you. I think that's going to wrap it. We are going to get to some questions here. We're going to dedicate an episode to a big barrage of question and answer. But you know what? I'm going to suggest give me till probably Wednesday, because Monday is dedicated for Bryce's stuff. Tuesday is probably going to be a breather day. And then Wednesday, we'll pick it right back up and get at it and just keep punching out for people. Because again, different circumstances, different parts of the world, that we have a lot more we can be doing here and accomplishing. Okay, loved ones, peace till then. Enjoy. Don't worry. Be happy. All's good. Thank you.